Amendment to the Convention on the Physical Protection of Nuclear Material, adopted on 8 July 2005, entry into force, in accordance with Paragraph 2 of Article 20 of the Convention, Depository, Director General of the IAEA. 1. The title of the Convention on the Physical Protection of Nuclear Material adopted on 26 October 1979, hereinafter referred to as the Convention, is replaced by the following title: Convention on the Physical Protection of Nuclear Material and Nuclear Facilities. 2. The preamble of the Convention is replaced by the following text: The states parties to this Convention, recognizing the right of all states to develop and apply nuclear energy for peaceful purposes and their legitimate interests in the potential benefits to be derived from the peaceful application of nuclear energy. Convinced of the need to facilitate international cooperation and the transfer of nuclear technology for the peaceful application of nuclear energy. Bearing in mind that physical protection is of vital importance for the protection of public health, safety, the environment and national and international security. Having in mind the purposes and principles of the Charter of the United Nations concerning the maintenance of international peace and security and the promotion of good neighborliness and friendly relations and cooperation among states. Considering that under the terms of Paragraph 4 of Article 2 of the Charter of the United Nations, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. Recalling the Declaration on Measures to Eliminate International Terrorism, annexed to General Assembly Resolution 4960 of 9 December 1994, desiring to avert the potential dangers posed by illicit trafficking, the unlawful taking and use of nuclear material and the sabotage of nuclear material and nuclear facilities, and noting that physical protection against such acts has become a matter of increased national and international concern. Deeply concerned by the worldwide escalation of acts of terrorism in all its forms and manifestations, and by the threats posed by international terrorism and organized crime. Believing that physical protection plays an important role in supporting nuclear non-proliferation and counter-terrorism objectives. Desiring through this convention to contribute to strengthening worldwide the physical protection of nuclear material and nuclear facilities used for peaceful purposes. Convinced that offenses relating to nuclear material and nuclear facilities are a matter of grave concern and that there is an urgent need to adopt appropriate and effective measures, or to strengthen existing measures, to ensure the prevention, detection and punishment of such offenses. Desiring to strengthen further international cooperation to establish, in conformity with the national law of each state party and with this convention, effective measures for the physical protection of nuclear material and nuclear facilities. Convinced that this convention should complement the safe use, storage and transport of nuclear material and the safe operation of nuclear facilities. Recognizing that there are internationally formulated physical protection recommendations that are updated from time to time which can provide guidance on contemporary means of achieving effective levels of physical protection. Recognizing also that effective physical protection of nuclear material and nuclear facilities used for military purposes is a responsibility of the state possessing such nuclear material and nuclear facilities, and understanding that such material and facilities are and will continue to be accorded stringent physical protection. Have agreed as follows. 3. In Article 1 of the Convention, after paragraph C, 2 new paragraphs are added as follows. D. Nuclear facility means a facility, including associated buildings and equipment, in which nuclear material is produced, processed, used, handled, stored or disposed of. If damage to or interference with such facility could lead to the release of significant amounts of radiation or radioactive material, e. Sabotage means any deliberate act directed against a nuclear facility or nuclear material in use, storage or transport which could directly or indirectly endanger the health and safety of personnel, the public or the environment by exposure to radiation or release of radioactive substances. 4. After Article 1 of the Convention, a new Article 1A is added as follows. Article 1A. The purposes of this convention are to achieve and maintain worldwide effective physical protection of nuclear material used for peaceful purposes and of nuclear facilities used for peaceful purposes, to prevent and combat offenses relating to such material and facilities worldwide, as well as to facilitate cooperation among states parties to those ends. 5. Article 2 of the Convention is replaced by the following text. 1. This convention shall apply to nuclear material used for peaceful purposes in use, storage and transport, and to nuclear facilities used for peaceful purposes, provided, however, that Articles 3 and 4 and Paragraph 4 of Article 5 of this convention shall only apply to such nuclear material while in international nuclear transport. 2. The responsibility for the establishment, implementation and maintenance of a physical protection regime within a state party rests entirely with that state. 3. Apart from the commitments expressly undertaken by states parties under this convention, nothing in this convention shall be interpreted as affecting the sovereign rights of a state. 4. A. Nothing in this convention shall affect other rights, obligations and responsibilities of states parties under international law, in particular the purposes and principles of the Charter of the United Nations and international humanitarian law. B. The activities of armed forces during an armed conflict, as those terms are understood under international humanitarian law, which are governed by that law, are not governed by this convention, and the activities undertaken by the military forces of a state in the exercise of their official duties, inasmuch as they are governed by other rules of international law, are not governed by this convention. C. Nothing in this convention shall be construed as a lawful authorization to use or threaten to use force against nuclear material or nuclear facilities used for peaceful purposes. D. Nothing in this convention condones or makes lawful otherwise unlawful acts, nor precludes prosecution under other laws. 5. This convention shall not apply to nuclear material used or retained for military purposes or to a nuclear facility containing such material. 6. After Article 2 of the Convention, a new Article 2A is added as follows. Article 2A. 1. Each state party shall establish, implement and maintain an appropriate physical protection regime applicable to nuclear material and nuclear facilities under its jurisdiction, with the aim of a. Protecting against theft and other unlawful taking of nuclear material in use, storage and transport. b. Ensuring the implementation of rapid and comprehensive measures to locate and, where appropriate, recover missing or stolen nuclear material. When the material is located outside its territory, that state party shall act in accordance with Article 5. c. Protecting nuclear material and nuclear facilities against sabotage and d. Mitigating or minimizing the radiological consequences of sabotage. 2. In implementing Paragraph 1, each state party shall a. Establish and maintain a legislative and regulatory framework to govern physical protection. b. Establish or designate a competent authority or authorities responsible for the implementation of the legislative and regulatory framework and c. Take other appropriate measures necessary for the physical protection of nuclear material and nuclear facilities. 3. In implementing the obligations under Paragraphs 1 and 2, each state party shall, without prejudice to any other provisions of this convention, apply insofar as is reasonable and practicable the following fundamental principles of physical protection of nuclear material and nuclear facilities. Fundamental Principle A. Responsibility of the state. The responsibility for the establishment, implementation and maintenance of a physical protection regime within a state rests entirely with that state. Fundamental Principle B. Responsibilities during international transport. The responsibility of a state for ensuring that nuclear material is adequately protected extends to the international transport thereof, until that responsibility is properly transferred to another state, as appropriate. Fundamental Principle C. Legislative and regulatory framework. The state is responsible for establishing and maintaining a legislative and regulatory framework to govern physical protection. This framework should provide for the establishment of applicable physical protection requirements and include a system of evaluation and licensing or other procedures to grant authorization. This framework should include a system of inspection of nuclear facilities and transport to verify compliance with applicable requirements and conditions of the license or other authorizing document, and to establish a means to enforce applicable requirements and conditions, including effective sanctions. Fundamental Principle D. Competent authority. The state should establish or designate a competent authority which is responsible for the implementation of the legislative and regulatory framework, and is provided with adequate authority, competence and financial and human resources to fulfill its assigned responsibilities. The state should take steps to ensure an effective independence between the functions of the state's competent authority and those of any other body in charge of the promotion or utilization of nuclear energy. Fundamental Principle E. Responsibility of the license holders. The responsibilities for implementing the various elements of physical protection within a state should be clearly identified. The state should ensure that the prime responsibility for the implementation of physical protection of nuclear material or of nuclear facilities rests with the holders of the relevant licenses or of other authorizing documents, for example, operators or shippers. Fundamental Principle F. Security culture. All organizations involved in implementing physical protection should give due priority to the security culture, to its development and maintenance necessary to ensure its effective implementation in the entire organization. Fundamental Principle G. Threat. The state's physical protection should be based on the state's current evaluation of the threat. Fundamental Principle H. Graded approach. Physical protection requirements should be based on a graded approach, taking into account the current evaluation of the threat, the relative attractiveness, the nature of the material and potential consequences associated with the unauthorized removal of nuclear material and with the sabotage against nuclear material or nuclear facilities. Fundamental Principle I. Defense in depth. The state's requirements for physical protection should reflect a concept of several layers and methods of protection, structural or other technical, personnel and organizational, that have to be overcome or circumvented by an adversary in order to achieve his objectives. Fundamental Principle J. Quality assurance. A quality assurance policy and quality assurance programs should be established and implemented with a view to providing confidence that specified requirements for all activities important to physical protection are satisfied. Fundamental Principle K. Contingency plans. Contingency, emergency, plans to respond to unauthorized removal of nuclear material or sabotage of nuclear facilities or nuclear material, or attempts thereof, should be prepared and appropriately exercised by all license holders and authorities concerned. Fundamental Principle L. Confidentiality. The state should establish requirements for protecting the confidentiality of information, the unauthorized disclosure of which could compromise the physical protection of nuclear material and nuclear facilities. 4. A. The provisions of this article shall not apply to any nuclear material which the state party reasonably decides does not need to be subject to the physical protection regime established pursuant to paragraph 1, taking into account the nature of the material, its quantity and relative attractiveness and the potential radiological and other consequences associated with any unauthorized act directed against it and the current evaluation of the threat against it. B. Nuclear material which is not subject to the provisions of this article pursuant to subparagraph A, should be protected in accordance with prudent management practice. 7. Article 5 of the Convention is replaced by the following text. 1. States parties shall identify and make known to each other directly or through the International Atomic Energy Agency their point of contact in relation to matters within the scope of this convention. 2. In the case of theft, robbery or any other unlawful taking of nuclear material or credible threat thereof, states parties shall, in accordance with their national law, provide cooperation and assistance to the maximum feasible extent in the recovery and protection of such material to any state that so requests. In particular, a state party shall take appropriate steps to inform as soon as possible other states, which appear to it to be concerned, of any theft, robbery or other unlawful taking of nuclear material or credible threat thereof, and to inform, where appropriate, the International Atomic Energy Agency and other relevant international organizations. b. In doing so, as appropriate, the states parties concerned shall exchange information with each other, the International Atomic Energy Agency and other relevant international organizations with a view to protecting threatened nuclear material, verifying the integrity of the shipping container or recovering unlawfully taken nuclear material, and shall coordinate their efforts through diplomatic and other agreed channels. 2. Render assistance, if requested. 3. Ensure the return of recovered nuclear material stolen or missing as a consequence of the above-mentioned events. The means of implementation of this cooperation shall be determined by the states parties concerned. 3. In the case of a credible threat of sabotage of nuclear material or a nuclear facility, or in the case of sabotage thereof, states parties shall, to the maximum feasible extent, in accordance with their national law and consistent with their relevant obligations under international law, cooperate as follows. a. If a state party has knowledge of a credible threat of sabotage of nuclear material or a nuclear facility in another state, the former shall decide on appropriate steps to be taken in order to inform that state as soon as possible and, where appropriate, the International Atomic Energy Agency and other relevant international organizations of that threat, with a view to preventing the sabotage. b. In the case of sabotage of nuclear material or a nuclear facility in a state party, and if in its view other states are likely to be radiologically affected, the former, without prejudice to its other obligations under international law, shall take appropriate steps to inform as soon as possible the state or the states which are likely to be radiologically affected, and to inform, where appropriate, the International Atomic Energy Agency and other relevant international organizations, with a view to minimizing or mitigating the radiological consequences thereof. c. If in the context of subparagraphs A and B, a state party requests assistance, each state party to which a request for assistance is directed shall promptly decide and notify the requesting state party, directly or through the International Atomic Energy Agency, whether it is in a position to render the assistance requested and the scope and terms of the assistance that may be rendered. d. Coordination of the cooperation under subparagraphs A, 2, c, shall be through diplomatic or other agreed channels. The means of implementation of this cooperation shall be determined bilaterally or multilaterally by the states parties concerned. 4. States parties shall cooperate and consult, as appropriate, with each other directly or through the International Atomic Energy Agency and other relevant international organizations, with a view to obtaining guidance on the design, maintenance and improvement of systems of physical protection of nuclear material in international transport. 5. A state party may consult and cooperate, as appropriate, with other states parties directly or through the International Atomic Energy Agency and other relevant international organizations, with a view to obtaining their guidance on the design, maintenance and improvement of its national system of physical protection of nuclear material in domestic use, storage and transport, and of nuclear facilities. 8. Article 6 of the Convention is replaced by the following text. 1. States parties shall take appropriate measures consistent with their national law to protect the confidentiality of any information which they receive in confidence by virtue of the provisions of this convention from another state party or through participation in an activity carried out for the implementation of this convention. If states parties provide information to international organizations or to states that are not parties to this convention in confidence, steps shall be taken to ensure that the confidentiality of such information is protected. A state party that has received information in confidence from another state party may provide this information to third parties only with the consent of that other state party. 2. States parties shall not be required by this convention to provide any information which they are not permitted to communicate pursuant to national law or which would jeopardize the security of the state concerned or the physical protection of nuclear material or nuclear facilities. 9. Paragraph 1 of Article 7 of the Convention is replaced by the following text. 1. The intentional commission of a. An act without lawful authority which constitutes the receipt, possession, use, transfer, alteration, disposal or dispersal of nuclear material and which causes or is likely to cause death or serious injury to any person or substantial damage to property or to the environment. B. A theft or robbery of nuclear material. C. An embezzlement or fraudulent obtaining of nuclear material. D. An act which constitutes the carrying, sending, or moving of nuclear material into or out of a state without lawful authority. E. An act directed against a nuclear facility, or an act interfering with the operation of a nuclear facility, where the offender intentionally causes, or where he knows that the act is likely to cause, death or serious injury to any person or substantial damage to property or to the environment by exposure to radiation or release of radioactive substances. Unless the act is undertaken in conformity with the national law of the state party in the territory of which the nuclear facility is situated. F. An act constituting a demand for nuclear material by threat or use of force or by any other form of intimidation. G. A threat. I. To use nuclear material to cause death or serious injury to any person or substantial damage to property or to the environment or to commit the offense described in subparagraph E, or 2. To commit an offense described in subparagraphs B and E, in order to compel a natural or legal person, international organization or state to do or to refrain from doing any act. H. An attempt to commit any offense described in subparagraphs A, 2, E. I. An act which constitutes participation in any offense described in subparagraphs A, 2, H. J. An act of any person who organizes or directs others to commit an offense described in subparagraphs A, 2, H, and K. An act which contributes to the commission of any offense described in subparagraphs A, 2, H, by a group of persons acting with a common purpose. Such act shall be intentional and shall either I. Be made with the aim of furthering the criminal activity or criminal purpose of the group, where such activity or purpose involves the commission of an offense described in subparagraphs A, 2, G, or 2. Be made in the knowledge of the intention of the group to commit an offense described in subparagraphs A, 2, G. Shall be made a punishable offense by each state party under its national law. 10. After Article 11 of the Convention, two new articles, Article 11A and Article 11B, are added as follows. Article 11A. None of the offences set forth in Article 7 shall be regarded for the purposes of extradition or mutual legal assistance, as a political offence or as an offence connected with a political offence or as an offence inspired by political motives. Accordingly, A request for extradition or for mutual legal assistance based on such an offense may not be refused on the sole ground that it concerns a political offense or an offense connected with a political offense or an offense inspired by political motives. Article 11b. Nothing in this convention shall be interpreted as imposing an obligation to extradite or to afford mutual legal assistance, if the requested state party has substantial grounds for believing that the request for extradition for offences set forth in Article 7 or for mutual legal assistance with respect to such offences has been made for the purpose of prosecuting or punishing a person on account of that person's race, religion, nationality, ethnic origin or political opinion, or that compliance with the request would cause prejudice to that person's position for any of these reasons. 11. After Article 13 of the Convention, a new Article 13a is added as follows. Article 13a. Nothing in this convention shall affect the transfer of nuclear technology for peaceful purposes that is undertaken to strengthen the physical protection of nuclear material and nuclear facilities. 12. Paragraph 3 of Article 14 of the Convention is replaced by the following text. 3. Where an offense involves nuclear material in domestic use, storage or transport, and both the alleged offender and the nuclear material remain in the territory of the state party in which the offense was committed, or where an offense involves a nuclear facility and the alleged offender remains in the territory of the state party in which the offense was committed, nothing in this convention shall be interpreted as requiring that state party to provide information concerning criminal proceedings arising out of such an offense. 13. Article 16 of the Convention is replaced by the following text. 1. A conference of states parties shall be convened by the depository 5 years after the entry into force of the amendment adopted on the 8th of July 2005 to review the implementation of this convention and its adequacy as concerns the preamble, the whole of the operative part and the annexes in the light of the then prevailing situation. 2. At intervals of not less than 5 years thereafter, the majority of states parties may obtain, by submitting a proposal to this effect to the depository, the convening of further conferences with the same objective. 14. Footnote B of Annex 2 of the Convention is replaced by the following text. B. Material not irradiated in a reactor or material irradiated in a reactor but with a radiation level equal to or less than 1 gray-hour, 100 rads-hour, at 1 meter unshielded. 15. Footnote E of Annex 2 of the Convention is replaced by the following text. Other fuel which by virtue of its original fissile material content is classified as Category Iron 2 before irradiation may be reduced 1 category level while the radiation level from the fuel exceeds 1 gray-hour, 100 rads-hour, at 1 meter unshielded.